Hey, 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 it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Lock Talk 24/7. So, this is an OVO, about to say OVO, a Jersey Drake, a Lawbury Drake, however you want to call him. This is his defamation case update. So, there have been new filings on the docket, and this is in regards to the case against Universal Music Group. I still need to do an update in regards to the deposition request for the Texas case. As you all know, that he's requesting depositions against iHeartRadio as well as UMG in Texas, but I think their hearing is scheduled for March, if I'm not mistaken. I did an update on that. So it's not really much of an update until they have the hearing. But in regards to this defamation case, there have been a few filings, one from UMG as well as an opposition filing from Drake. So let's hop right on into it. All right, so this was submitted on February 21st. It says that we represent defendant UMG Recordings. In the above captioned matter, we write to request that the initial pretrial conference currently scheduled for April 2nd be adjourned pending resolution of the UMG's forthcoming motion to dismiss, which is due on March, what is that, 17th, 2025. Now, if you guys don't know what adjourn mean, they're just trying to ensure that they hold off on the pretrial conference until it's decided what will happen at the hearing for the motion to dismiss. It says the purpose of the conference will be to set a case schedule, but as will be shown in UMG's motion to dismiss, this case should not proceed because plaintiff fails to state any claims. At minimum, the conference is premature until the court determines whether and in what form, if at all, the case will move forward. Indeed, the pleadings are currently in flux. Pursuant to separate correspondence, plaintiff has agreed to withdraw certain key allegations in his complaint. We understand that plaintiff opposes adjournment of the conference because he wants to start discovery, but discovery is premature for the same reasons. And in any event, plaintiff has not yet even delivered Rule 34 documents request. And then we thank the court for its time and attention to this matter. Hold on. Rule 34. Rule 34. Is that disclosures? Hold up. Ba, 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 ba. Governs how parties can request documents, information, and physical items from other parties. Okay. So it pretty much, okay. So Federal Rule 34. It governs how parties can request documents, information, and physical items from other parties. So they have to do this first before they go into discovery, because discovery is requesting information, documents, and all this other stuff. So you have to pretty much see how it is going to be um requested. All right, so going into Drake's opposition. Pursuant to Local Rule 7.1, paragraph E and sections 3A and E of the court's individual rules and practices in civil procedures, plaintiff Aubrey Drake Graham respectfully writes in opposition to defendant UMG Recordings Inc.'s request to adjourn the initial pretrial conference currently scheduled for April 2nd, 2025. Further, plaintiff requests moves for an order requiring UMG to comply with Federal Rule of Civil Procedure. Let's see, 26F by participating in Rule 26F conference no later than March 5th, 2025. Let me blow this up if y'all want to read along. UMG's request to adjourn is unsupported by the law or the facts. Indeed, UMG does not cite a single case suggesting, let alone holding, that adjournment is appropriate under these circumstances. The reason for UMG's failure to marshal any supporting authority is straightforward. UMG is attempting to circumvent the rules, as well as the local rules, by obtaining a stay of discovery without actually moving for one. UMG's counsel has disclosed to plaintiff's counsel that UMG intends to file a motion to dismiss and that UMG may well seek an extension of its deadlines to make that filing, though UMG has not actually committed to either. In response to multiple requests to schedule a 26F conference, which UMG has refused at each turn, UMG's counsel has ignored the fact that it is fully capable of participating in a 26F conference now because it prefers delay. Specifically, in an email sent just minutes before UMG filed its request to adjourn, UMG's counsel explained that UMG believes that it should not have to meet and confer with plaintiffs pursuant to Rule 26F, the conference, until 21 days before the PTC, a pretrial conference. Notwithstanding that the text of Rule 26F requires that the parties to confer as soon as practicable. The court should decline UMG's transparent attempt to obtain a stay of discovery, which it apparently seeks so it can further ponder its motion to dismiss. UMG has neither moved to dismiss nor moved to stay a discovery, and its attempt to achieve the latter by delaying the former are appropriate. So what they're saying, Drake's saying, look, they haven't even put in a request to pause discovery or even filed a motion to dismiss, but asking the court to adjourn. Make it make sense. That's the words of Drake. All right, let's see what he talk about. So plaintiff first notified UMG regarding his legal claims on July 24th, 2024, and the counsel conferred a number of times regarding those claims prior to initiating this litigation. By no later than September 16th, 2024, UMG had actual notice that plaintiff intended to sue UMG regarding these claims. On January 15, 2025, plaintiff filed suit against UMG asserting claims for defamation, harassment in the second degree, the violation of the New York General Business Law, Section 349, and promptly served the complaint. Prior to service, UMG asked to extend its time to respond to the complaint until April 7, 2025, 82 days after the filing and 76 days after service. Plaintiff ultimately consented to UMG seeking an extension of time until March 17th. While discussing UMG's requested extension, plaintiff requested that the parties agree to complete briefing schedule. Counsel for UMG declined, suggesting it was premature to set further schedules because UMG was contemplating requesting even more time to draft and file its motions to dismiss. Notwithstanding its representation that UMG hoped and expected to file a response by March 17th. UMG then filed this motion for an extension without any additional briefing dates, which the court granted. The next day, on January 22nd, 2025, the court entered an order setting a pretrial conference for April 2nd, 2025, and directed counsel to confer with each other prior to the conference regarding settlement and each of the other subjects to be considered at the Federal Rule of Civil Procedure 16 conference, and to file a proposed civil case management plan and scheduling order by March 26, 2025. While conferring on plaintiff's request to set a full briefing schedule, UMG suggested that the parties seek to adjourn the pretrial conference until after a decision on the motion to dismiss. Plaintiff's counsel rejected any adjournment, explaining that plaintiff is eager to begin discovery as soon as possible. Plaintiff later filed a letter with UMG's consent, requesting the court set the response and reply deadlines. The court granted the full briefing schedule. On February 6, 2025, plaintiff emailed UMG asking for availability for the 26F conference. UMG's counsel did not provide any reason why it would not be practicable to hold a 26F conference, but instead stated, given that our current deadline for the Rule 26F conference is not until March 12th, we believe this request is premature. UMG continued We can discuss the timing of the Rule 26F conference closer to that date, assuming the current deadline remains in place at that time. In response, plaintiff reiterated his request, explaining that because Rule 26F1 is clear that the parties must confer as soon as practicable. I said practicable. The deadline to complete a 26F conference is not at all relevant. To that end, plaintiff asked for 30 to 45 minutes to confer. UMG refused to not at all relevant. On February 19th, let's see, plaintiff again asked to set a meet and confer. UMG again characterized the request was premature, this time explaining that it was filing a request to adjourn the pretrial conference, which it contends triggers the deadline for 26F conference. UMG filed the request to adjourn minutes later. All right, so now Drake is saying that the court should deny UMG's request to adjourn. The court should deny UMG's request to adjourn because it is improper attempt to stay discovery without having so moved. Instead, the court should hold the pretrial conference as scheduled and order UMG to comply with the requirements of Rule 26F. If it is well established that trial courts have broad authority to oversee and set discovery schedules as appropriate for each case, including deciding to hold one or more pretrial conferences. Let's see. And courts in this district routinely denies requests for adjournment. UMG claims that the pretrial conference is premature because the complaint fails to state a claim or because the complaint is in flux, but neither of these arguments justify UMG's requested relief. Putting aside the fact that the complaint does not state a claim, the fact that UMG plans to file a motion to dismiss does not justify adjournment. Neither the rules nor the local rules provide for any automatic stay of discovery pending a motion to dismiss. Had the federal rules contemplated that a motion to dismiss under Federal Rules of Civil Procedure 12b6 would stay discovery, they would contain such a provision. Courts do not grant stays of discovery routinely, but rather only where good cause exists, considering 1. Whether a defendant has made a strong showing that the plaintiff's claims are unmeritless. 2. The breadth of the discovery and the burden of responding to it. And 3. The risk of unfair prejudice to the party opposing the stay. And the court has already determined that it is appropriate to hold the PTC while the UMG's forthcoming motion to dismiss is pending. The court set the pretrial conference for April 2nd, 2025, having already received UMG's request to extend its deadline to respond to the complaint. The request to adjourn does not even attempt to satisfy UMG's burdens. UMG does not even attempt to argue that the complaint is facially without merit, sorry. The complaint spells out in detail overwhelming facts which, taken as true, establish the elements for each of plaintiff's claim. UMG also makes no argument as to the breadth of burden of discovery. Nor could it because UMG has refused to confer with plaintiff on the kind of discovery plaintiff believes is necessary to prove his claims. And delaying discovery would unfairly prejudice plaintiff who is continuing to suffer the consequences of UMG's defamatory campaign. Indeed, at the same time UMG has been delaying here, UMG launched new campaigns to further spread the defamatory content, including at the 2025 Super Bowl halftime show, which had over 133.5 million viewers. Plaintiff has concerns that delayed discovery may result in a loss of electronic discovery from UMG and or third parties, particularly because it is likely that relevant discovery is contained on communication platforms that are not preserved in a normal course, such as text, social media, and ephemeral messaging applications. UMG separately claims that the PTC pretrial conference is premature because the complaint is in flux, but this is misleading and legally irrelevant. In response to a letter from UMG, plaintiff has agreed to address UMG's concerns regarding a single factual allegation that even if plaintiff were to concede everything UMG has argued with about that allegation, which he does not, would result in changes of 5 paragraphs of the complaint spanning 237 paragraphs over 81 pages. UMG does not explain why this correction warrants adjournment, nor does it even claim that an amendment affecting these 5 paragraphs would impact the preparation for the pretrial conference. In all events, UMG's position, which relies with on no cited authorities, is plainly wrong, as complaints as often amended after discovery has been commenced, including following motions to dismiss. That's true. Now, here's the okay. So what Drake is saying here is that the previous letter that I read, the request for adjournment, they didn't even cite cases to support their reasoning to adjourn or pretty much push off or delay the pretrial conference. They just asked for it to be adjourned. That's it, that's all. So when you are submitting these letters, and y'all, we have read plenty of letters, they usually cite certain cases to support their reasoning for doing something in that particular case. Just like what they did here. As you can see, they cited. See, you know, I think that's how you say it, Jeffrey versus Maxwell or Chase Manhattan Court. Like they actually cited cases. Um, where do I leave off at? Okay. The court should compel UMG to comply with the rules. So the court, he's asking that the court make UMG comply with the rules. Separately, plaintiff respectfully requests that this court under UMG to comply with Rule 26F by participating in a 26F conference by no later than March 5th. Rule 26F1 provides that the parties must confer as soon as practicable. Practicable. Why can't I say that? The requirement that the parties confer to develop a discovery plan may be the single most important provision in the discovery architecture of Rule 26. Holding a conference is practicable where it is reasonably capable of being accomplished. Courts may compel a conference where one party baselessly seeks to avoid or delay holding a Rule 26F conference, and they cited other cases to support that. Here, it is practicable for the parties to hold a 26F conference because it is reasonably capable of being accomplished. UMG has not, because it cannot, argue that it is incapable of participating in a 26F conference, especially when plaintiff has offered to make himself available at a day and time amenable to UMG. The UMG also does not contest the plain text of Rule 26, but instead argues that it can ignore the rule's requirements because it also provides a deadline by which parties must confer, at least 21 days before a scheduling conference is to be held or a scheduling order is due under Rule 16b. The existence of a deadline by the conference must be completed does not mean that the parties must or even may wait until the last minute. Doing so would nullify the rule's requirement that the parties must confer as soon as practicable. Having provided no reason for why a 26F conference would be impracticable and having no motion to stay discovery, UMG should be required to promptly participate in a 26F conference as the text requires. The court should order UMG to participate in a 26F conference by no later than March 5th, which is 21 days prior to the deadline for the parties to submit a proposed case management plan and scheduling order. Hmm. All in all, UMG has not filed a motion to dismiss. UMG also has not filed a request to well, I guess they kind of did, but they didn't cite properly cases relevant, not relevant, but supportive of what the art whatever argument that they're trying to make. And so that is the loophole that uh whatchamacallit, Drake's attorney, I couldn't even think of his name. That's sad. That Drake's attorney is going to use. Like, court, you got to make them do something because they're not doing what they're supposed to do. They're not following the rules. So he's being a big baby at this point. But I do get what they're saying. You can't ask for something when you haven't filed that. So I do see UMG possibly filing a motion to dismiss, but we shall see. We shall see. Wait, I'm gonna go back because I didn't even see that on the docket. Hold on. Hold on. Let's go back. Let's look at this docket right quick. All right. So the complaint, issuance, affidavit of service. All right. So they asked for a motion to extend time to respond to the complaint, which was granted January 22nd. Pro hoc vice was entered. Order was granted for the Pro Hoc Vice. This is what y'all gonna see. If anytime somebody files a motion to appear Pro Hoc Vice, you have to wait till this updates on the court docket. You can't automatically say that a case has been that an attorney is approved to practice under a Pro Hoc Vice if the order hasn't been granted yet. But anywho's, yeah, so there's no motion to dismiss on here. So UMG, I'm not sure what y'all are doing, but I think y'all might need to kind of play by the rules because these federal court judges ain't playing with y'all. But y'all let me know what y'all think about Drake including the further defamation claim because our boy said, "Say Drake, I heard you like 'em young." That boy was hurt. Kendra looked straight in the camera, y'all. Drake was hurt about that. He was hurt. And he's going to continue to suffer as long as Not Like Us is playing on our radio stations. As long as we could go onto YouTube and watch the halftime show, he will continue to be defamed and lose out. Anywho, y'all tell me what y'all think about this in the comments below. Don't forget to like, share, and subscribe. Until then, you all be blessed and I'm out. Bye.